Please be seated. Veuillez vous asseoir.
L'audience est reprise. Je vais donner la parole à Maître Dimitri, mais avant, j'aimerais rappeler quelque chose. Maître, nous avions déjà reçu les écritures de toutes les parties. Et donc, je demande à toutes les parties, et spécialement à vous, de ne pas répéter ce que nous avons déjà lu. Et en plus, nous avions prévu la première session pour examiner les observations par rapport à la règle 122, paragraphe 3 du règlement des procédures de preuve. Là, je commence à avoir des inquiétudes parce que nous commençons à dépasser notre calendrier. Alors, maître, s'il vous plaît, essayez de vous résumer. Vous avez 3 minutes pour conclure et ensuite, je vais donner la parole à d'autres parties. S'il vous plaît. Merci beaucoup.
Mr. President,
Maître Knosch.
apologies. Just to assist the chamber and my learned friends, the defense of Mr. Ngaissona has probably not more than 15 minutes to take the time of the court for the 122.3 observation. So we have no objection if the chamber allows to lend some of our time to our friends of the Yekatom team, if that would accelerate the proceedings. Thank you.
Très bien, Maître Knops. Puis-je savoir combien de minutes voudrait utiliser Maître Van der Pouye?
Thank you very much, Mr. President. I don't anticipate that I will have much or use much time to respond to the arguments of Ms. Dimitri or with respect to any response to Mr. Knops's arguments that I anticipate. I know that the legal representatives of victims may have some observations as well that they wish to make.
Oui, Monsieur Van der Pouye, mais vous n'allez pas utiliser ne fût-ce que 5 minutes? C'est pour évaluer un tout petit peu. Hein.
I think that I wouldn't imagine more than, yes, about 5 or 10 minutes.
Merci beaucoup. Et le représentant des victimes, s'il vous plaît.
Merci, Monsieur le Président. Je vais présenter les observations pour les deux équipes et j'anticipe selon, bien évidemment, ce que le bureau du procureur dira également, mais j'anticipe pas plus que 15 minutes. Merci.
Merci beaucoup, maître. La Chambre remercie la défense de Ngaissona pour sa générosité et la Chambre remercie évidemment le bureau du procureur et les représentants des victimes. Néanmoins, nous sommes en retard sur notre calendrier. Alors, Maître Dimitri, la Chambre vous accorde 5 minutes pour conclure, s'il vous plaît, parce que nous avons déjà lu vos écritures.
Merci, Monsieur le Président. Monsieur, Madame les juges, je vais faire aussi vite que je peux et je m'excuse par avance aux interprètes. L'accusation pourrait prétendre que la défense a fait un grand nombre de demandes de levée d'expurgation qui n'ont pu être traitées rapidement avec ses ressources limitées. L'accusation est seule responsable du retard causé par le règlement des différends, non seulement parce que le fardeau de justifier les expurgations leur incombe, mais également pour les raisons suivantes. En premier lieu, rappelons que la défense a débuté les échanges interpartis avec l'accusation pour la première fois le 30 avril 2019. Une série de lettres a suivi le 14 juin 2019, il y a plus de 3 mois. Ces correspondances sont restées lettres mortes pendant plusieurs semaines. Les problèmes se sont donc accumulés à un point tel que l'accusation a manqué de temps pour les traiter en temps utile. Deuxièmement, anticipant d'ores et déjà que l'accusation allait repousser indéfiniment le contentieux lié aux expurgations en évitant de répondre promptement aux correspondances de la défense, celle-ci avait expressément demandé à la Chambre de restreindre les délais de réponse aux correspondances sur les expurgations. Voir l'écriture 47, paragraphes 68-69. Troisièmement, après que la Chambre eut déterminé que les délais de rigueur n'étaient pas nécessaires et qu'elle comptait sur le professionnalisme des deux parties pour coopérer de bonne foi, la défense a initié des rencontres et des suivis par téléphone en avril et mai 2019. L'accusation a néanmoins décidé de retarder la résolution rapide des questions soulevées. Étant donné qu'au paragraphe 31 de la décision portant numéro 64, la Chambre a déclaré, et je cite, « In its decision on the confirmation of charges, the Chamber shall take into account only the version of evidence that was disclosed between the parties. » La défense demande par la présente à la Chambre d'aller au-delà et de ne pas tenir compte des déclarations contenant des expurgations injustifiées et utilisées par l'accusation pour appuyer les divers chefs d'accusation auxquels fait face M. Yekatom. L'importance des expurgations appliquées, comme en témoignent les exemples que j'ai donnés, a empêché M. Yekatom d'enquêter, de présenter des preuves et de contester celles présentées par l'accusation. L'accusation a eu amplement le temps d'examiner ces questions avant l'audience de confirmation des charges et de promptement coopérer de bonne foi avec la défense. Elle a choisi de ne pas le faire. Tout ajournement porterait également préjudice à M. Yekatom, qui est détenu depuis près d'1 an et qui s'est opposé, plus d'une fois, à tout report de l'audience de confirmation des charges. La défense ne peut se prononcer sur les questions de crédibilité et de fiabilité relatives à la preuve portée par l'accusation. L'exercice des droits de la défense est entravé lorsque l'identité des témoins oculaires ou des victimes présumées sont expurgées. Si M. Yekatom avait disposé pleinement des droits prévus à l'article 61.6 du statut, les éléments de preuve auraient inévitablement été contestés. Au regard de l'impossibilité pour M. Yekatom d'exercer pleinement ses droits, en raison du manque de diligence de l'accusation et de son incapacité à trouver un juste équilibre entre la nécessité d'appliquer des expurgations et les intérêts et les droits de M. Yekatom, l'accusation devrait être privée de l'utilisation de ces déclarations. Si l'accusation a fait preuve du même manque de diligence dans son examen des éléments de preuve relatifs à la Séléka que dans son application des expurgations standards, une conclusion s'impose. L'accusation a fort probablement en sa possession une quantité non négligeable de documents recueillis dans le cadre de son enquête sur la Séléka qui n'ont pas été transmis à la défense. De nombreux éléments qui permettraient à M. Yekatom, notamment, de démontrer que les civils que Mme la procureure l'accuse d'avoir attaqués étaient en réalité armés, engagés dans les combats et faisaient partie des combattants Séléka. Aujourd'hui, l'accusation devrait être sommée de faire un choix. Aujourd'hui, afin de préserver l'intégrité de la procédure et en toute équité pour le droit de M. Yekatom de contester pleinement les éléments de preuve de l'accusation ou de présenter ses propres éléments de preuve, l'accusation devrait mettre un terme à la non-divulgation des éléments de preuve relatifs à la Séléka. L'accusation a eu amplement le temps de déterminer si elle avait recueilli suffisamment d'éléments de preuve pour poursuivre les membres de la Séléka pour crimes de guerre et crimes contre l'humanité, particulièrement à la lumière de sa déclaration du 24 septembre 2014. Aujourd'hui, l'accusation devrait soit arrêter et poursuivre les membres de la Séléka qu'elle considère comme suspects des crimes relevant de la compétence de la Cour, ce qui lui permettrait de s'acquitter pleinement de ses obligations de divulgation, soit elle devrait être sommée de divulguer ces éléments sans délai. M. Yekatom et la défense ne sont pas assis dans la galerie du public. M. Yekatom est assis dans cette salle d'audience et fait face à de graves accusations de crimes de guerre et de crimes contre l'humanité. Il est partie à la procédure et devrait pouvoir y participer pleinement. Nous invitons donc la Chambre à joindre l'examen des observations que je viens tout juste de présenter à celui des charges et des éléments de preuve et à délibérer sur l'opportunité des expurgations et des demandes de la défense. La défense reconnaît que la Chambre a déterminé que la protection de l'enquête en cours et future de l'accusation prévalait sur les intérêts de la défense et que, conséquemment, aucune des expurgations appliquées relatives à l'enquête sur la Séléka ne pouvait être levée. Toutefois, il existe un point de rupture, au-delà duquel les droits de M. Yekatom, a fortiori lorsqu'il est détenu, doivent l'emporter sur la protection de l'enquête en cours et à venir de l'accusation. Ce point de rupture est passé, maintenant que l'audience de confirmation des charges de M. Yekatom est en cours. Il n'est pas possible d'aller de l'avant à n'importe quel prix. Si l'accès à ces informations cruciales ne peut pas être accordé, la procédure de confirmation n'a aucune chance d'être équitable. Si la procédure ne peut pas être équitable, elle doit être abandonnée. L'accusation a déjà invoqué comme argument dans une requête antérieure, et je cite, « the unexpected speed at which the suspects were arrested ». Cet argument ne peut et ne devrait pas servir de justification pour refuser à M. Yekatom un processus de confirmation des charges équitable jusqu'à ce que l'accusation soit prête. La Chambre peut ordonner la libération immédiate de M. Yekatom, le renvoyer en République centrafricaine. Et lorsque l'accusation sera prête à agir, sans préjudice des droits de M. Yekatom, elle pourra poursuivre. Dans l'intervalle, M. Yekatom ne devrait pas devoir attendre un jour de plus en détention, que l'accusation soit prête à agir équitablement. Je vous remercie.
Merci beaucoup, Maître Dimitri, pour votre coopération et pour vos efforts pour conclure. À présent, je passe la parole à Maître Knops pour ses observations par rapport à ce que Maître Dimitri a dit, mais surtout par rapport à ses propres observations sur la règle 122, paragraphe 3 du règlement des procédures d'épreuve.
Yes, that's it. Thank you very much, Mr. President, Your Honors. Mr. President, I will not repeat our submissions of 16 September. I will raise one additional procedural point which is in line with our submissions of 16 September, and this relates to the scope of Rule 122, Section 4. Mr. President, you raised this procedural point this morning by saying, it's page 18 of the transcripts, lines 1 till 6, that observations in accordance with Rule 1223 cannot longer be made subsequently either during the confirmation of the charges hearing or during the trial itself, if applicable. That's, of course, a very valid observation. We ask the Chamber, based on Article 31, Section 1 of the Vienna Convention on the Law of Treaties, to apply this rule, 122, Section 4, such that Mr. Ngaissona, after this hearing is over, has not forfeited his right to raise procedural or substantive observations on the proceedings itself, if, of course, the court would at all confirm the charges. Now, why I'm asking the court to make such a ruling, Mr. President? Mr. Ngaissona faces 111 charges, covering 16 alleged crimes. His team had 30 days to prepare the hearing after the issuance of this DCC, which ranges 249 pages with annexes over 700 pages and 1,291 footnotes. On top of this, the defense had to deal within the 30-day time limit with 1,546 pages of disclosures, 7 disclosures. Of course, this raises the point, the procedural point, regarding the scope, the interpretation of Rule 122, Section 4, as Your Honours explained this morning. It is in light of this observation that we have submitted on the 16th September to the Chamber our request, our notification, that, first of all, Mr. Ngaissona cannot be deemed to have forfeited any right to raise procedural matters in case the confirmation of charges would be granted by this court. And secondly, and this is a new point, which is not in our submission as such, but it follows quite logically from our submissions, we asked the Chamber to make a ruling that in this specific situation, Rule 122, Section 4 will not apply in light of Article 31, Section 1 of the Vienna Convention on the Law of Treaties, which says, and as we all know, the Rome Statute is a treaty, that a treaty should be interpreted in good faith in accordance with its purpose and object and in the proper context. And we submit that in the instant case, it would, in contravention to Article 31, Section 1 of the Vienna Convention on the Law of Treaties, to hold against Mr. Ngaissona, if the confirmation of charges would be granted at all, to hold against him that he didn't raise any procedural points within the 30 time limits of before the hearing. And Mr. President, why we're also saying this? You honors have seen in our submissions very briefly that Regulation 38, Section 3 under G of the regulations of the court stipulates that the description of the charges should not exceed 30 pages, and that pursuant to Rule 121, Section 3 of the RPE, that document not exceeding 30 pages should provide it no later than 30 days before the date of the confirmation of charges hearing. Your Honours can simply observe that this time frame was considerably shorter than provided under the statutory framework of the court in light of the actual number of the DCC, 249, with annexes over 700 pages. I refer him, Mr. President, Your Honours, to the Alassane case, where the Chamber required the prosecution to inform the defense at the earliest opportunity, and this was well in advance of 60 days leading to the date of the confirmation of charges hearing. And the court stipulated that the notification should include any material change in the factual basis of the allegations which were to be found in the arrest warrant, so as to satisfy the requirements of Article 67, Section 1 of the statute. You find this in paragraph 31, Mr. President, of the Alassane decision ICC/01/12/01/18/20 1/143, the English version. Interestingly, the judges cited in their ruling on this point the practical manual of May 2017, where you can find the rationale of this time limitation. My second point, Mr. President, why we asked the court to make a ruling in the case of Mr. Ngaissona that Rule 1224 will not be applied in his case based on the Vienna Convention on the Law of Treaties. This relates to two observations. First, the Chamber must have observed that, first, there is a considerable expansion in terms of quantity of the charges and the geographical areas which cover those charges. And secondly, there's a change in the qualification of certain alleged crimes. First element, you find several examples. I give you one example, the location of Zawa, which did not previously feature in the arrest warrant, has been added to the DCC and comprises 4 new counts. 5 new counts on its face appear to the locality of Bangui, 4 new counts, locations Boda, 4 additional counts to the Lobaya prefecture, Berberati, and Carnot. There are many other examples, just to give you some of them. In this regard, Mr. President, the Chamber must also have observed that despite your ruling that there was insufficient evidence to support the finding that Mr. Ngaissona bared criminal responsibility for alleged crimes committed in the region Gwen, and this was already decided by the Chamber before, the prosecution nonetheless included this location in the DCC in the paragraphs 575 and further. In sum, in total, around 34 additional new charges have been added to the DCC, including the counts in relation to the mentioned district Gwen. Secondly, as observed, there's a change in the qualification of the crimes. Just 2 examples, Mr. President. The count of rape, attempted rape, both as an alleged crime against humanity as well as an alleged war crime, did not feature in the arrest warrant, but does appear now in the DCC in different locations like Bangui, Boda, Yolake, Bosangoa. Other crimes also feature for the first time in the DCC of Mr. Ngaissona, including alleged war crimes of committing outrages on personal dignity in Bangui, as well as the alleged war crime of degrading treatment in Boda, Berberati, Carnot, and Yaloke. Conclusion. The Chamber is confronted with a DCC which both geographically, in terms of quantity, but also in terms of qualification of crimes, reflects a considerable expansion of the case of Mr. Ngaissona. And this is why, Mr. President, we submit that the Chamber should, in this specific case, based on the elements of Article 31, Section 1 of the Vienna Convention on the Law of Treaties, interpret Rule 122, Section 4, such, in accordance with good faith, the context and the object and purpose of the treaty, whereby the rules in my submissions are a derivative of the treaty, such that Mr. Ngaissona, if a confirmation of charges would be granted, which will be disputed by the defense, will not have forfeited his right to raise any procedural or substantive arguments should they arise, if applicable, in a later stage of proceedings. That would be, as your honors will observe, a deviation from the principle of Rule 122, Section 4. But in light of this specific context and the time frame which was in our submission not honored, in line with the statutory framework of the court, and in light of the huge amount of new charges and documents, would be in accordance with the proper interpretation of the Rule 112, Section 4. So this is what we ask, in addition to the request we submitted to the Chamber on the 16th September. My last observation, Mr. President, and to conclude, it's the second point of procedural law, which you will not find in our submissions of the 16th September. The LRV submission of 13th September 2019, with respect to Mr. Ngaissona's alleged liability, in the paragraphs 9 till 13, the LRV addresses this point. In our submissions, this submission has no legal basis. You'll find in these submissions by the LRV an indirect request for an expansion of a certain criminal liability mode, indirectly seeking for an amendment of those liability modes in the case of Mr. Ngaissona, and in our submission that would contravene the rationale of Rule 121, Section 4 of the RPE, which says that any amendment of the charges should be notified to the pretrial chamber and the person no later than 15 days before the date of the hearing. Now, of course, the LRV will submit in their response that this rule is addressed to the prosecution. But we submit that, in light also here of the purpose and object of this rule, 121, Section 4, it should equally apply to the position of the LRV. And in this regard, we, as we submit, find support for this proposition in the partially dissenting opinion of Judge George Pikis in the Appeals Chamber decision of Thomas Lubanga, 11 July 2008, paragraph 41, and paragraph 16, in particular paragraph 16, where the Honorable Judge Pikis stated that it's not the victim's domain to either reinforce the prosecution or dispute the defense. And we submit that the submission of the LRB on this point is therefore beyond the realm of their procedural rights, and this in our submission also expands to any argument seeking for an amendment of the charges in these stages of the confirmation of charges proceedings. We thank you very much for your attention, Mr. President.
Merci beaucoup, Maître Knops. Je vais à présent donner la parole aux représentants légaux des victimes pour intervenir avant de passer au procureur qui va plutôt conclure. Parce que vous avez été mentionné aussi dans les observations de la défense de M. Ngaissona. Madame, vous avez la parole.
Merci, Monsieur le Président. Je comprends que j'interviens seulement d'abord sur la question de Maître Knops. C'est bien correct.
Et vous continuez aussi sur la règle 122, paragraphe 3.
D'accord. Thank you, Mr. President. I will start with the last submission by my learned colleague, Maître Knops, and then I will provide a few observations on the other observations by the defense of Mr. Yekatom. starting with the last point, which was just raised by Mr. Knops, I think that there is fundamentally a misinterpretation of what the purpose of the submission by the legal representative filed on 13th of September. In our submissions, we clearly indicated that victims have some concern in relation to the fact that Article 28 of the Rome Statute does not appear per se as a possible mode of liability of Mr. Ngaissona in the document containing the charges. It appears that mode of liability in the document containing the charges in respect of Mr. Yekatom. So first of all, it is a legitimate concern by the victims to understand why this mode of liability was not put forward. Second, going more to the substance of the objection, the legal representatives are not asking any amendment of the charges. We are fully aware that this is not our role and that we cannot even activate this request before the pre-trial chamber. But the inherent power of a pre-trial chamber could allow that chamber to eventually change the mode of liability as pleaded by the prosecution if, at the end of a confirmation of a charges hearing, the evidence will show that Mr. Ngaissona could also be imputated with Article 28 of the Rome Statute. It was, by the way, already the case in a previous case, also concerning the Central African Republic. In the Bemba case, ab origine, the prosecution did not include it in the document containing the charges responsibility of Mr. Bemba under Article 28 of the Rome Statute. In that case, at the end of a confirmation of charges hearing, the pre-trial chamber asked expressly the prosecution to also foresee liability of Mr. Bemba under Article 28 of Rome Statute. The hearing was adjourned in order for the parties and participants to submit observation on that mode of liability. Therefore, it's our submission, Your Honor, that there is nothing in the text of the court impeding legal representatives to put forward before the chamber a concerns legitimate by the victims in relation to the possibility of eventually include liability under Article 28 of the statute at the end of a confirmation of a charges hearing once all evidence have been heard by the chamber. Now, Your Honor, I have few submissions in relation to the defense observation of Mr. Yekatom, and I could maybe first conclude with the defense of Mr. Ngaissona. It would be more easier for me. I'm sorry, I was just reshuffling my submission following the hearing. As far as the second point of the defense of Mr. Ngaissona, is concerned, I'm referring to Rule 122, Paragraph 4 of the Rules of Procedure and Evidence, and the request by the defense of Mr. Ngaissona to not bar the defense from eventually submit further objection after the confirmation of the charge hearing. Well, I have essentially two comments. The first one is that the request specifically goes against the wording of Rule 122.4 of Rules of Procedure and Evidence. And this has been confirmed as recent as 17 July 2019 by the Appeals Chamber in the Ongwen case, which was actually dealing with the interpretation of Rule 122, Paragraph 4, because Mr. Ongwen pleaded before the trial chamber that he was not barred from presenting some objections at the trial stage. The trial chamber ruled that he was barred, and this was confirmed by the appeal chamber. For the record, it could be useful to state the full decision. ICC 0204 0115 1562 0804 17 July 2019, specifically paragraph 130. Second, and still on the objection by the defense of Mr. Ngaissona, the legal representative considered that the defense has not offered any valid or reasonable argument to depart from the clear text of Rule 122, paragraph 4. Incidentally, I don't see why we should use Article 41(1) of the Vienna Convention when it's clearly set, the rule, in the text of the court and confirmed by the practice of the court itself. I think I will leave the prosecutor to deal with the 30-day period. The only remark that I would like to make in that respect is that it is our opinion that the defense should have reasonably expected a lengthy document and prepared accordingly. And the defense should also have reasonably expected filings coming at the eve of a confirmation of a charges hearing, particularly because Mr. Knops is in any case a learned colleague already used to litigation before the ICC. Turning briefly to the submissions by the defense for Mr. Yekatom. Your Honor, our first concern is in relation to the request for a permanent stay of proceeding. Now, a permanent stay of proceeding, allow me to be clear on that, Your Honor, would entirely quash the legitimate rights and interests of the participating victims in this case. The defense, in any case, has not demonstrated that the proposed relief to discontinue the proceeding against Mr. Yekatom is the right one at this point of the proceeding. In particular, it's our submission that the defense has not demonstrated, one, that the rights of the suspect have been violated to such an extent that the essential preconditions of a fair trial are missing, and two, there is no sufficient indication that this will be resolved during the trial process. These two cumulative elements have been considered by the general practice of the court as cumulative in order to arrive to a possible discontinuance of proceedings. It's not the case here. In this regard, it could maybe be useful to recall the Lubanga judgment of 2006, the appeals chamber judgment, and I'm referring in paragraph 24, which indicate, and I quote, "It is the responsibility of a relevant chamber to remedy breaches of a process in the interest of justice, using the tools available within the trial process." We submit this apply mutatis mutandis to pre-trial proceedings, "to cure the underlying obstacles to a fair trial, thereby allowing the proceedings to proceed speedily to a conclusion on its merit. Doing so rather than resorting to the significantly more drastic remedy of a stay of proceedings is in the interest not only of the victims and of international community as a whole, who wish to see justice done, but also the accused, who is potentially left in limbo, awaiting a decision on the merits before the ICC. Now, we submit that in this vein, exactly applying that principle, this chamber has recently issued decisions preventing any possible breach of fair trial. I'm referring to the decision in relation to the ex parte filings, on which the chamber has ruled recently, including with a decision of yesterday granting the request by the Yekatom defense. And I'm also referring to the allegations in relation to the excessive use of non-standard redactions, which the chamber also ruled upon as recently as 13 September 2019, indicating expressly, and I quote, "The information already available to the defense, along with the additional disclosure already ordered and provided, including the disclosure ordered in the present ruling, will sufficiently enable, I underline, sufficiently enable the defense to exercise their rights in relation to the charges." The reference, Your Honor, is to the decision of this chamber 0113, 0118, 341, 13 September 2019, paragraph 27. And the previous decision I quoted, for the correctness of the record, is in the Lubanga Appeals number ICC 0104 0106 772, 14 December 2006, paragraph 24. In any case, Your Honor, we wish to recall that the suspects and accused rights to disclosure is not absolute. There are competing interests to be taken into account and at stake that the chamber has to weigh before taking any decision, including the obligation to protect victims and witnesses. To conclude, Your Honor, granting the suspect a stay of proceeding on the grounds that Mr. Yekatom's rights were overwhelmingly derogated, to use the words of the defense, by authorizing excessive non-standard redaction and a misuse of ex parte proceedings, would result, in our submission, in the irreparable prejudice to victims awaiting justice in this case. Not only would they have awaited prosecution of the suspects for many years, but their hopes of seeing these proceedings moving forward expeditiously and conclude would be scattered, and any reasonable expectation to justice buried with this case. Thank you, Your Honor.
Merci beaucoup, Maître, pour vos observations en vertu de la règle 122, paragraphe 3 du règlement des procédures et des preuves. À présent, je vais passer la parole au procureur pour ses propres observations également. Monsieur le procureur.
Thank you very much, Mr. President, Your Honors. I'll be brief, and if, with your permission, I would like to go in reverse order. so that I can address the observations of my colleagues. First, with respect to the legal representatives for victims, with respect to the observation concerning the application of Article 28 to Mr. Ngaissona, I will say that the prosecution has brought these charges based on the evidence as a result of the investigation that is carried out, and which it is carrying out. To that extent, the charges that are brought against these suspects represent the fruits of that investigation as it currently stands. I'll leave it there with respect to the application of Article 28 in respect of Mr. Ngaissona. I agree with a number of observations that have been made by my colleague, Ms. Masida. I will point out a couple of things. First, in respect of the Ngaissona defense's application at this stage to the Chamber to refer to the Vienna Convention on the Law of Treaties as a means to countermand the express language of Rule 122.4 of the Rules of Procedure and Evidence, I think is not appropriate, and it exceeds the scope of appropriate observations to be made within the dictates of the rules. The express language of the rule is as follows: at no subsequent point may the objections and observations made under Sub-Rule 3 be raised or made again in the confirmation or trial proceedings. There's simply no ambiguity there. And the reference to Rule 122.3 refers to objections or observations concerning an issue related to the proper conduct of the proceedings prior to the confirmation hearing. With respect to Mr. Ngaissona's argument concerning the time or length of time provided under the rules for the preparation of the defense in relation to the confirmation hearing, I would note that the Ngaissona defense, and if I'm not mistaken, the Yekatom defense as well, specifically opposed the extension of time that was sought by the prosecution in order to proceed with the confirmation hearing. So it is a bit ironic that at this stage, on the day of the hearing itself, or shortly before, the Ngaissona defense is raising the inadequacy of the time that is allotted to them in order to prepare. And yet still, even as of today, has not made an application to the Chamber to adjourn the proceedings in order to accommodate that need or alleged need to prepare adequately for the confirmation process. So I don't believe that there's any merit in respect of that application, if it is an application at all, as opposed to a mere observation concerning the time. As to the scope of the case itself, the number of charges that are pled in the document containing the charges derive from almost the identical facts and circumstances which are specified in the warrant of arrest. The number of crimes and the characterization of those crimes is clearly inferable from the decision of this Chamber in the issuance of the warrant for Mr. Ngaissona's arrest, which was effectuated in December of last year. His transfer to the court was in January of this year. And between then and now, our position is that the defense of Mr. Ngaissona has had ample time to anticipate what the document containing the charges was likely to contain on the basis of the warrant itself. It is true that there have been other charges added in respect of the document containing the charges that are not contained in the warrant of arrest. That, of course, is well within the right of the prosecution to do, and is specifically provided for under the regulatory framework of the court. Notwithstanding, the prosecution has signaled to the defense that it intended to bring charges in addition to those specified in the arrest warrant in previous filings and in conversations with defense counsel. So we don't believe that there is any merit with respect to that application as well. Moreover, the length of the document containing the charges is one thing. The substance and the evidence which supports the charges is another. The fact that a document shouldn't be more than 30 pages long has no bearing on the 30 days that is foreseen under the rules for the preparation of the defense, because the preparation of the defense is dependent upon the quantum of evidence which supports those charges, or the quantum of evidence to be adduced during the course of the confirmation hearing. In these circumstances, the document containing the charges makes specific reference to that evidence, which explains its length and will reduce, in fact, the length of the confirmation hearing at which such evidence is foreseen to be produced before the chamber. So there's no argument with respect to that. I will turn now, if I may, to the Yekatom defense briefly. The Yekatom defense has raised several issues with respect to its access to the record concerning ex parte filings, with respect to the nature and extent of redactions, and with respect to the disclosure that has occurred until this point. There is nothing in the observations or objections put forth by the Yekatom defense that has not already been put before this chamber and this chamber has decided upon. As my colleague, Ms. Masida, indicated, the chamber has already decided all of the issues that have been raised by the Yekatom defense. The extent of the redactions that have been raised, in which we have been dealing with the Yekatom defense on an inter partes basis, as well as through the intervention of the chamber, has already been determined in the chamber's recent decision bringing to a close the necessary disclosure for the purposes, and limited purposes, I add, of the confirmation hearing or the confirmation process. The chamber, as I recall, also pointed out that should the case be confirmed, disclosure that may be necessary for the preparation of trial will continue, as it should, given the limited nature and scope of these proceedings. The chamber has also dealt with the issue of ex parte proceedings and ex parte filings, and has also dealt with a number of disclosure requests that have been made by the Yekatom defense and disposed of all of them. In fact, there's one pending for which a response is not due until the 27th, I think, of this month. And so we will respond to that in due course. That application has no bearing whatsoever on the sufficiency or the fairness of these proceedings. In addition, the Yekatom defense has sought leave to appeal an issue arising in respect to the scope of the redactions that have been made, which this chamber has considered and appropriately denied. The Office of the Prosecutor has abided by its disclosure obligations entirely and in good faith, as I believe the defense on both sides is well aware. We've abided by the rules, by the statute itself, by the precedent of the court, and by the orders and directions of this chamber, scrupulously and without failing. We believe that that is a sufficient enough basis to guarantee and ensure the fairness of these proceedings, and I see no reason raised by the defense or anyone to postpone these proceedings any further. That is our submission, Mr. President, Your Honors. If there is any question that you would like me to answer, I am at your disposal.
Merci beaucoup, Monsieur le procureur. Pour le moment, donc, nous avons fait le tour de la table. Chacune des parties et chacun des participants ont exposé leurs observations et ont répondu aux observations des autres. Et je vais me tourner vers mes collègues s'il y a un juge qui a une question. Sinon, la Chambre va se déterminer. Mes collègues n'ont pas de questions, moi-même je n'en ai pas. Alors, la Chambre a pris bonne note de toutes les observations et de toutes les réponses et elle va délibérer. En vertu de la règle 122, paragraphe 6 du règlement de procédure et de preuve, la Chambre statuera sur ces observations dans la décision de confirmation des charges. Pour le moment, donc, sans plus attendre, nous allons poursuivre notre audience. Je vais maintenant inviter le bureau du procureur à exposer ses observations sur le fond de l'affaire. Je rappelle que le bureau du procureur dispose de 6 heures, 6, pour ces observations. J'aimerais rappeler aussi que pour le bon travail de nos interprètes, il est souhaitable de parler doucement et de marquer des pauses chaque fois à la fin de vos phrases. Monsieur le procureur, vous avez la parole.
Thank you, Mr. President, Your Honors. As I mentioned earlier today, would you like me to pause or wait?
Non, c'est bon, vous pouvez y aller, mais je voudrais seulement vous rappeler que nous avons reçu vos écritures et qu'il n'est pas nécessaire de répéter oralement ce que nous avons déjà lu. Vous pouvez vous résumer et aller au point nouveau s'il y en a. Aux éléments nouveaux. Merci.
Okay, thank you again. I do apologize in advance insofar as our submissions are pre-prepared to some extent, or rather a great extent, I would say, in anticipation of today's hearing. So there may be some repetition, but I think it is necessary repetition and is in full accord with the purposes and object of the confirmation hearing. As I mentioned a bit earlier, unfortunately, the prosecutor of the International Criminal Court, Madame Fatou Bensouda, who would normally be giving an address at the opening of the prosecution's submissions, is unavailable and unable to attend today due to unforeseen circumstances. On her behalf, I will read in her submissions in just a moment. The first part of these submissions will be in French, Mr. President, just so that the interpreters are aware, and I will do my best to do them justice. Monsieur le Président, Madame et Monsieur le Juge, Patrice Edouard Ngaissona et Alfred Yekatom sont ici aujourd'hui en raison de leur implication criminelle dans une campagne de violence et de terreur menée contre des civils, incluant des enfants. Une campagne exécutée par les anti-Balaka entre décembre 2013 et décembre 2014, dans le cadre d'un conflit armé qui a dévasté la République centrafricaine à partir de l'année 2012. Comme le document de notification des charges l'affirme, M. Ngaissona et M. Yekatom ont conjointement commis, concouru ou apporté toute autre forme d'assistance à la commission des graves crimes poursuivis dans cette affaire qui ont été perpétrés par les anti-Balaka. M. Yekatom a également commis personnellement certains crimes, a ordonné des crimes ou n'a pas pris toutes les mesures nécessaires et raisonnables qui étaient en son pouvoir pour empêcher ou réprimer les crimes commis par ses subordonnés qui étaient sous son commandement et son contrôle effectif. Avant 2012, les musulmans et les chrétiens vivaient paisiblement ensemble en République centrafricaine. Ils grandissaient ensemble, se mariaient ensemble, étaient voisins, amis, membres des mêmes familles. Les violences chroniques qui avaient affligé le pays pendant des décennies ne les avaient jamais divisés selon les lignes religieuses. Cela a pourtant changé à la fin de l'année 2012. Un groupe armé connu sous le nom de Seleka a émergé au nord-est de la République centrafricaine. La Seleka, qui était une coalition constituée de combattants principalement musulmans, s'est rebellée contre le régime du président François Bozizé. Cette insurrection, qui a débuté dans le nord-est du pays, s'est renforcée et progressant vers Bangui. Le 24 mars 2013, la Seleka est finalement descendue sur la capitale et a chassé le gouvernement en place. Après que Bozizé et ceux qui lui étaient loyaux ont fui en exil, la Seleka s'est approprié les ressources, les structures et l'appareil militaire de l'État centrafricain. Une fois au pouvoir, le Seleka a mis en place une politique de terre brûlée et de terreur visant les anciens fiefs de Bozizé et ses soutiens. Avec votre permission, Monsieur le Président, Madame et Monsieur le Juge, je vais à présent poursuivre en anglais.
S'il vous plaît, poursuivez en anglais.
During the months following the 24 March 2013 coup, a counter-movement began to build within the country. Widespread atrocities drove people to defend themselves, their communities, and their families against the Seleka's rule. It was also driven by a desire for vengeance and revenge against those perceived responsible for the Seleka's crimes and those perceived as traitors for having sided with them. The Muslim population. One anti-Balaka fighter describes that, quote, under the Seleka rule, people felt helpless. And this triggered the creation of the anti-Balaka. It came from everywhere, not one person. Initially, people only gathered to protect themselves. When the Seleka entered villages, they killed men, women, and children. Some of the boys managed to escape and they organized to defend themselves. If you take 100 anti-Balaka, everyone has their reasons for joining. They can tell you what the Seleka did to them in order to turn them into the anti-Balaka. For another witness, it was his mother's murder that led him to fight. Quote, "When I heard my mother was killed and her body was left out on the street, I left to see my brothers, and we buried her next to her house. When somebody kills your mother, you don't feel like yourself anymore. I was angry, and I did anything that came into my mind. I couldn't forgive. I decided to create a rebellion. When my mother was killed, I got very angry, and I wanted to avenge her death." Many victims of Seleka crimes held all Muslims responsible. One witness said, quote, in French, les Arabes, ceux-là, ont tué ma mère, mon père. C'est trop. C'est trop. Il faut les Arabes droit quitter. Il faut les Arabes droit quitter dans la Centrafrique. Ici, c'est mon pays. Tous les Arabes, n'importe. Mais sinon, je dois me continuer à tuer, même les Arabes, me venger. The Central African Republic has a tradition whereby civilians have formed community-based self-defense groups. These groups have long been used in Central African politics, able to be activated when the need arises. Ngaissona knew of them. And in the context of this case, he knew of their motivation to exact revenge and retribution against Muslims for Seleka atrocities. From exile, Mr. Ngaissona and other members of Bozize's inner circle used these groups. They exploited the vengeance and hatred felt by the people to create a formidable fighting force which could defeat the Seleka, opening the way for them to reclaim power, what we describe in the document containing the charges as the Strategic Common Plan. The evidence submitted demonstrates that Mr. Ngaissona and his co-perpetrators enhanced the capabilities of these insular self-defense groups, coordinating them, resourcing them, and promoting their collective action. In doing so, Mr. Ngaissona knew that the fighting force to which he had contributed to forming and developing would, in the ordinary course of events, violently target the Muslim civilian population in Western CAR and commit the war crimes and crimes against humanity with which he is charged. From mid-2013, the anti-Balaka ranks swelled as Mr. Ngaissona encouraged, portrayed, and promoted them as liberators, national heroes. They saw themselves and were seen by Central Africans as saviors, freeing people from the bloody reign of the Seleka. Mr. Ngaissona called them his children. At first, the anti-Balaka was celebrated. One witness explains, quote, "Women in the neighborhood were rubbing metal pot lids together, egging the young men on. They were chanting, Alala Alagawe, which means in Sango, they are here, they arrived." But soon after the anti-Balaka, like the Seleka, they murdered and oppressed. They betrayed the freedom struggle values and the hope once held out for them. A Christian tells, quote, "We believed that they were here to liberate us from the Seleka. I was not aware that they intended to target Muslim civilians. Soon I became frightened of them and started detesting them as they quickly changed their behavior," end quote. As news of anti-Balaka attacks upon Muslims spread throughout the country, another witness explains how some refused to leave. Quote, "They could not believe that their Christian brothers would turn against them. End quote. Yet the Muslim rhetoric of Bozizé and his inner circle, pitting Christians against Muslims as perceived supporters of the Seleka, was the reality. Muslims were seen as traitors, collaborators, foreigners. The Anti-Balaka made all Muslims their targets. They destroyed mosques. They looted and burnt down their shops and homes. They decimated communities, expelling Muslims on an unprecedented scale. They murdered, they raped women and children. The harsh reality for Muslims was that there was no place for them in CAR, their own country. In the pursuit to oust the Seleka and reclaim power, Mr. Ngaissona and other members of the Strategic Common Plan enhanced the capacity of anti-Balaka groups to commit the charged crimes. As Minister of Youth, Sports, Art, and Culture, Mr. Ngaissona wielded authority and influence. He encouraged the youth to take up arms. He mobilized and coordinated groups on the ground. He was wealthy, and he could resource them. Mr. Ngaissona provided the Anti-Balaka with money. He helped to support them. He assisted their access to weapons and ammunition. These and other essential contributions helped transform the Anti-Balaka into a force that was eventually able to defeat the Seleka regime. But also, and importantly, a force capable of committing the charged crimes on the scale and magnitude in which they were perpetrated. Mr. Yekatom led one such anti-Balaka group, styling himself as Commander Rambo. He, together with his group, violently targeted the Muslim population in Bangui, Boeing, and other areas in southwestern CAR. They expelled Muslims, they murdered them, and Mr. Yekatom personally committed crimes. Mr. Yekatom armed and trained his group, thousands of men strong. In his words to one of his soldiers, quote, "The purpose of the training was so we could kill Muslims and Selekas," end quote. His soldiers obeyed. They openly voiced their intention to slaughter the Muslim population. One witness, a Central African Muslim, was one of many victims forced to flee his home in the seminal 5 December 2013 anti-Balaka attack on Bangui. Mr. Ngaissona and Mr. Yekatom are both charged with crimes which arise from this coordinated offensive, among others. Watching from a hole in the wall of his compound, the witness describes this, quote, "Between 8 and 9 a.m., the Anti-Balaka chased a Muslim man and caught him in the road in front of my house. The attackers were shouting, 'This is an Arab.' I could hear the man pleading for help, but the Anti-Balaka beat him up and killed him. I saw the body of this man lying on the road. I was calling everywhere for help to get my family safely out of the neighborhood. I feared for the safety of my family, and I was desperate to get them out to a safe location. I believe we had no option but to flee from my neighborhood. The consequence of staying in the house would have been us all being killed." The violent targeting of Muslims was an anti-Balaka policy repeated in the western provinces. There were anti-Balaka elements spread from village to village. They came in armed convoys or on foot, looting, killing, and pillaging as they went. Huge swathes of the country were emptied through the flight and expulsion of their Muslim populations. Fearing for their lives, massive columns of displaced Muslims left their towns and villages. They fled wherever they could, including to neighboring countries. These unarmed men, women, and children were left highly vulnerable. They lacked protection and were often exposed and targeted on their desperate journey to safety. Men were frequently separated from women and children, and away from their male relatives, women were especially vulnerable. They were subjected to violence on the basis of their ethnicity, including violence of a sexual nature as one of the most degrading and humiliating forms. Defenseless civilians were confronted with anti-Balaka elements who knew that they could act with near impunity. One witness, a young Muslim girl, was part of a group who ran from the attacking anti-Balaka. She ran with her family to seek refuge with their imam. 4 members of her family died on their way. Hiding alone in an abandoned house, she was cornered by 5 anti-Balaka elements. As she was raped, she told them, quote, "I would rather be killed," end quote. Many who did not or could not flee their hometowns were corralled into enclaves. They were unable to leave without risking death. These enclaves were described by some as, quote, "an open-air prison," end quote. Those inside were often left to starve and die of preventable diseases. Your Honors, the anti-Balaka's attack on Muslim civilians in Western CAR, whether in Bangui or in the provinces, was not random, it was not spontaneous, but rather the evidence is that it occurred over a large territory and over a long period. It emerged from a singular common purpose and policy, and that was the violent targeting of the Muslim population and their perceived supporters in retribution for Seleka crimes and atrocities. The anti-Balaka was an organized militia. It was effective. And Mr. Ngaissona was atop the group's national coordination. The anti-Balaka had full communication ability with respect to the lines of authority, as the evidence demonstrates. Anti-Balaka comm zones, zone commanders, they received instructions about planned future attacks. They reported back to the National Coordination on disciplinary issues, their positions, and the outcomes of those attacks. Trained soldiers reinforced the group's ranks and were needed to implement the strategic and operational common plans. Yekatom's role and group were an important part of those plans. He was a military commander, he had charge of thousands of men, and he organized his group in a military-like hierarchy. He was respected, he was feared, and his orders were to be obeyed. Whether on the ground or coordinating from a distance, both Mr. Yekatom and Mr. Ngaissona knew that the charged crimes were occurring or that they would occur in the ordinary course of the events that they set in place and put in motion. Both knew that the campaigns and deployment of troops filled with hatred and vengeance against Muslims would be directed not only towards the armed Seleka, but also Muslim civilians. They knew that these attacks would involve children, not yet 15 years old. Those children enlisted and used in hostilities were also inhumanely treated and subjected to violence. Children were also ordered to commit crimes against civilians. One child describes his experience in the anti-Balaka. And he said that when their chiefs, quote, caught an Arab alive, they will order us to stab him. We were instructed to stab or cut his ear off by the section chiefs. When the prisoner was exhausted, we would dig a shallow grave about knee height, put him in, and then the chiefs will come back and kill him, end quote. These children, exploited, violated, and forced to participate in atrocities, are victims of Mr. Yekatom's and Mr. Ngaissona's crimes. They stand alongside countless of Central Africans turned against one another to serve the political aims of powerful men. Mr. President, Your Honors, the charges before you today are serious, and the evidence submitted requires their confirmation. The Muslim residents of the Central African Republic were relentlessly terrorized. Perceived as complicit with the Seleka, they were victimized by a violent group intent on their elimination. On the evidence before you, substantial grounds exist to believe that Mr. Ngaissona is responsible for the charged crimes. He played a key role in and essentially contributed to the strategic common plan. He helped develop it. He assisted its implementation, organizing and coordinating anti-Balaka chiefs and comm zones, leading tens of thousands of anti-Balaka elements. He held status, authority, and influence, which he wielded over these groups in Bangui and in the western provinces. The evidence submitted also shows substantial grounds to believe that Mr. Yekatom is responsible for the crimes committed by his troops in areas under his control. In implementing his operational common plan and to effect the purpose common to all the charged anti-Balaka crimes, Mr. Yekatom deployed troops and commanded them in their violent targeting of the Muslim civilian population. He failed to prevent or punish troops under his effective command and control, knowing that they were committing or about to commit these crimes. Moreover, he personally ordered and committed crimes. Mr. President, Your Honors, Patrice Edouard Ngaissona and Alfred Yekatom must be held to account, and this matter bound over for trial. I thank you. That concludes the submissions of Madam Prosecutor. Mr. President, I see that it's 1 o'clock, and I would defer to the chamber as to how to proceed. I have a presentation that I will make myself, which I anticipate will take about 45 minutes or 50 minutes. So I wonder if it might be a good time to break, and then we can resume as the chamber wishes in an hour or so.
Merci beaucoup, Monsieur Van der Pouye. La Chambre vous remercie pour votre présentation. La Chambre comprend très bien que Madame le procureur n'est pas là aujourd'hui. Quant à votre demande en ce qui concerne la suite, je pense, avec mes collègues, qu'il est bon d'arrêter maintenant et nous reprendrons donc à 14h35 minutes, 14h35 cet après-midi pour la suite de notre audience. Nous allons donc suspendre l'audience maintenant. Madame la greffière.
All rise, veuillez vous lever.